This hearing of the Committee on the Judiciary, Subcommittee on Commercial and Administrative Law will now come to order. I will now recognize myself for a brief statement. I have called today's hearing to shed light on the use of pretrial prosecution agreements in corporate crime cases, a growing practice that has so far been operating mostly in the shadows, without guidelines and without oversight. Today's hearing is not being held with prejudice for or against deferred prosecution and non-prosecution agreements, but rather with concern about the number of unanswered questions surrounding them. The concept of deferred prosecution originated as a rehabilitation option for nonviolent juvenile and drug offenders. After prosecutors file an indictment, the prosecution is put on hold in exchange for commitments by the offender to reform and provide restitution. If the offender meets the obligations in the agreement, prosecutors may ask a judge to dismiss the indictment. In the past 6 years, the Justice Department has increasingly relied upon a similar tool for white-collar crimes, usually involving private corporations. In such cases, an independent corporate monitor is often hired to determine whether the target corporation has complied with the obligations in the deferred prosecution or non-prosecution agreement. Late last year, I was troubled to learn of what appeared to be a backroom sweetheart deal where New Jersey U.S. Attorney Christopher Christie appointed John Ashcroft, the former Attorney General, to serve as an independent corporate monitor and collect fees between $28 and $52 million. I was also concerned to learn from press accounts that Mr. Ashcroft was selected with no public notice and no bidding, and that he had to use considerable time to prepare for the assignment and learn more about the business that he was contracted to monitor. When I continued to investigate the issue of deferred prosecution agreements and the appointment of independent corporate monitors, I discovered that the parties to these agreements were operating in a Wild West type of environment with no laws and no Justice Department guidelines. Less than 24 hours before today's hearing, the Department sent us a memo mapping out some guidance with regard to the selection and use of monitors. And while I do believe that this may be a good start, uncertainty still remains as to how monitors should be selected and how these agreements should be structured. The absence of standards governing how independent corporate monitors are selected has resulted in a hodgepodge of approaches across jurisdiction. For example, in several agreements, prosecutors selected the monitor, typically after consulting with the corporation. In others, the corporation selected the candidate. Additionally, a few agreements provide for collaboration among the corporation, regulators, and prosecutors in the selection. Finally, in at least 3 agreements, a court played a significant role in the monitor selection process. Furthermore, the current system lacks guidelines to direct how independent corporate monitors conduct oversight of the corporation once they have been selected. Most monitors are granted broad powers to gather information, institute policies, and oversee compliance. For example, in one matter, the monitor had the power to, quote, require any personnel action, including termination, regarding individuals who were engaged in or were responsible for the illegal conduct described in the information, end quote. In essence, the agreement allowed the monitor to act as the prosecutor, judge, and jury for these employees. While uncertainty is common in many aspects of deferred prosecution agreements, one thing does remain certain. The government has tremendous leverage over a corporation entering into an agreement. Corporations facing criminal prosecution have an unfair choice. They can either risk a conviction and perhaps even dissolution after trial, or be coerced into accepting the terms and the monitor that a prosecutor unilaterally believes are appropriate. Unfortunately, because of a lack of transparency in many aspects of deferred prosecution agreements, we still don't know the full scope of this issue. On January 10th, Chairman Conyers, Congressman Pascrell, and I sent a letter to the Justice Department requesting that the department disclose all deferred prosecution agreements and the individuals selected as monitors. It has been 2 months since our request, and we have yet to receive a response. While we patiently await the department's disclosure of information, this hearing serves as a critical starting point of bringing deferred prosecution agreements and the appointment of monitors out from behind the shadows. Accordingly, I look forward to probing these issues further and considering whether legislation in this area is appropriate. I would like to recognize now the ranking member of the full Judiciary Committee, Mr. Smith, who has joined us and has some opening words.
Thank you, Madam Chair. I really don't have an opening statement. I do want to, however, welcome former Attorney General John Ashcroft to our hearing today. I know what he's going to say, and I agree with it, and I just appreciate his taking the time to be here today. Madam Chair, I also want to read an excerpt from an article in the New York Times today that speaks to the subject matter that we're here to discuss. And here's the exact quote from the New York Times article today. Outside lawyers who have reviewed Mr. Ashcroft's fee schedule said it was not out of line. Madam Chair, if you read that in the New York Times, that says a whole lot. And so I just appreciate their commentary, and I appreciate your having this hearing today. With that, I'll yield back.
I thank the ranking member of the full committee, Mr. Smith, and would like to recognize at this time our distinguished ranking member of the subcommittee, Mr. Cannon.
Thank you, Madam Chair. I would ask unanimous consent to have my full statement entered into the record.
Without objections, order.
And I do that because I understand Mr. Ashcroft has a travel obligation he's informed the majority of and would need to leave at 12. And I think that he ought to have plenty of time to respond to the allegations that are being made. You made a point of Mr. Christie's involvement. He has been a remarkably effective prosecutor, and to the degree that becomes an issue, I hope that we can address that. But I would like to thank you, Madam Chair, for this hearing. As you know, we've talked about the concerns that I have with prosecutorial discretion, and we have a marvelous panel here for addressing that issue, and in particular, as it relates to these the matters that we have before us today. So I hope that we come out of here with a much expanded view of what the possibilities are for not only helping U.S. attorneys handle the extraordinary burdens that they have, but also helping us focus on how we in Congress, and particularly this committee, can become much more involved in the process of overseeing how prosecutorial discretion is handled throughout the country. So I want to thank you again for drawing this panel together. I want to thank all the panelists for being here today. I suspect this will be a very interesting hearing, and I hope we can clear the air and allow Mr. Ashcroft to have the opportunity to respond with particulars to the suggestions of the possibility of impropriety. Referring back to what Mr. Smith has just said, when the New York Times suggests that things don't seem out of line, it is probably a pretty good guess that they're not. But I think it's very important that we have the opportunity to air both the charges that have been sort of insinuated against Mr. Christie and also Mr. Ashcroft, and that we get beyond that and then start looking at we have a marvelous panel of people who actually understand these issues in great depth, and I hope we can plumb that understanding and learn how to do our job, or learn what we can do here to be much better at our job. So thank you, Madam Chair. I yield back.
I thank the gentleman for his statement. I would now like to recognize at this time Mr. Conyers, a distinguished member of the subcommittee and the chairman of the Judiciary Committee, the full Judiciary Committee. Mr. Conyers.
Thank you, Madam Chairwoman, for holding the hearings. You and Chris Cannon are to be commended, and I appreciate the constructive tone with which we're beginning these off. I welcome John Ashcroft as the former Attorney General, and likewise all the witnesses. All we're doing today, sir, is exploring the Department of Justice's use of corporate settlement agreements. We know that they are a useful prosecutorial tool. Several aspects of their implementation that require congressional oversight and possibly legislative attention, as has been suggested. Congressional oversight of these agreements is probably essential to provide transparency. We understand the importance of these agreements as effective prosecutorial tools and respect confidentiality concerns. We nonetheless want to know the number of agreements into which the department has entered these agreements and the details around them. I'm going to ask that of the Department of Justice. How many of these kinds of agreements are floating around? And it's important in light of the fact that the number of these agreements have increased dramatically during the tenure of our star witness here, former Attorney General John Ashcroft. In an effort to obtain information regarding the agreements, as Chairwoman Sanchez has indicated, we're still waiting to receive a response from the Attorney General. Now, despite the guidance that the Department released yesterday afternoon regarding the use of corporate monitors in these agreements, this guidance still fails to ensure uniformity in the agreements themselves. Indeed, some agreements require the implementation of compliance programs, restitution, and fines, while others do not. While it may be necessary to fashion some agreements on a case-by-case basis, and we concede that, general uniformity could ensure the fairest application. We hope that we will have these concerns addressed during the hearing today. We hope that the recently released Department guidelines regarding the selection of corporate monitors are successfully applied and implemented, because otherwise there is the potential for department politicization. One such example for this potential has arisen in the agreement between Zimmer Holdings and the United States Attorney's Office, in which Attorney Christopher Christie, who's been described here as a stellar U.S. attorney, a trial expert, but that we still have a problem with the naming of our former Attorney General, John Ashcroft, as corporate monitor. Pursuant to this agreement, they've agreed to pay Mr. Ashcroft's firm anywhere from between $28 and $52 million. And if it's not asking too much, we'd like to know exactly how much is involved here. Prior to the appointment of our former Attorney General, there was neither public notice of the monitor position nor any public bidding for the assignment that we know of. This highlights the concern that brings us all here this morning. We must assure the public that the Department of Justice is not rewarding political allies in a forum where prosecutorial independence is absolutely necessary. Our investigation into the removal of 9 U.S. attorneys has taught us, unfortunately, that the department can be politicized in a way that undermines public confidence. And so we hope that the department guidelines released yesterday accomplish the goal of restoring public confidence. And finally, there ought to be independent judicial oversight of corporate settlement agreements, because currently there's no transparency and no requirement that they be made public. Judicial oversight would help to ensure greater legitimacy of these agreements by providing a neutral decision maker to prevent abuses and politicization, as well as ensure proper completion of the terms of the agreements. And so I hope that all of our witnesses will help throw light on a subject that has not been examined up till now, and that's why I commend this committee and its leadership for holding this hearing today. Thank you, Madam Chair.
I thank the gentleman for his opening statement, and at this time I would like to welcome 2 of our colleagues who have joined us on the dais, Mr. Pascrell and Mr. Pallone. They are not members of the subcommittee, but they will be listening in and providing testimony for our second panel. Without objection, other members' opening statements will be included in the record. And without objection, the chair will be authorized to declare a recess of the hearing at any point. I am now pleased to introduce our witness panel for today's hearing. Our first witness is Mr. John Ashcroft. Mr. Ashcroft serves as chairman of the Ashcroft Group, LLC, which provides confidential strategic consulting and crisis counseling to major international corporations. Prior to forming the Ashcroft Group, Mr. Ashcroft served during the first term of President George W. Bush from 2001 until 2005 as the 79th U.S. Attorney General. During his tenure as Attorney General, the Corporate Fraud Task Force was established within the department to restore integrity to the marketplace. Prior to his appointment as Attorney General, Mr. Ashcroft was elected to the U.S. Senate in 1994 and served on the Senate Judiciary, Foreign Relations, and Commerce Committees. From 1985 through 1993, Mr. Ashcroft served as governor of Missouri and served as chairman of the nonpartisan National Governors Association in 1991 and 1992. He received awards from the Business Roundtable, U.S. Chamber of Commerce, and National Federation of Independent Businessmen for his service in the Senate. We want to welcome you, Mr. Ashcroft. Our second witness is Timothy Dickinson. Mr. Dickinson is a partner in the Washington, D.C. firm of Paul Hastings, Janofsky, and Walker, LLP. Mr. Dickinson's practice is devoted primarily to international commercial matters, including all aspects of political risk insurance, the Foreign Corrupt Practices Act, U.S. export laws, and economic sanctions. Mr. Dickinson works closely with a wide range of industries on FCPA matters, including establishment of compliance programs, due diligence and acquisitions, special investigations, and defense before U.S. regulators. In 2005, Mr. Dickinson was appointed independent expert by Monsanto as part of a deferred prosecution agreement with the Department of Justice. Mr. Dickinson is currently an adjunct professor at the University of Michigan Law School, where he teaches transnational law and international commercial transaction. He has served on the board of editors of the FCPA Reporter since 1997 and is the director of the International Law Institute's course on government integrity and anti-corruption initiatives. Welcome to you, Mr. Dickinson. Our third witness is David Nahmais. Is that correct pronunciation? Mr. Nahmais is the United States Attorney for the Northern District of Georgia. He serves as the Chief Federal Law Enforcement Officer in that district, representing the United States in all criminal and civil litigation in federal court. In January of 2005, Mr. Nahmais was appointed to serve on the Attorney General's Advisory Committee of United States Attorneys, which reviews and recommends policies for federal prosecutors nationwide. The Attorney General also appointed Mr. Nahmais as chairman of the White-Collar Crime Subcommittee in October of 2007. Prior to his appointment as a U.S. Attorney, Mr. Nahmais served as a Deputy Assistant Attorney General in the Criminal Division, the Fraud Section, the Appellate Section, and the Capital Case Unit. Mr. Nahmais practiced with the law firm of Hogan & Hartson in Washington, D.C., and served as a law clerk for Judge Lawrence Silberman of the U.S. Circuit Court for the District of Columbia and for Justice Antonin Scalia of the Supreme Court of the United States. Welcome to you, Mr. Nahmais. Our fourth witness is George Terwilliger. Is that correct pronunciation? Thank you. A partner with the law firm of White & Case, LLP. Mr. Terwilliger's clients include national and international companies and prominent individuals. He has represented the interests of major corporations and other institutions in civil and criminal enforcement proceedings, including financial crimes and environmental, antitrust, healthcare, and tax matters, among others. Prior to joining White & Case, LLP, Mr. Terwilliger served as a presidential appointee in 2 administrations. He was the Deputy Attorney General in charge of all Justice Department operations, including crisis response. He also served as a presidentially appointed United States Attorney for 5 years and for 8 years as a federal prosecutor. Welcome again to you. Our final witness on our first panel is Brandon Garrett. Professor Garrett joined the University of Virginia Law School faculty in 2005 as an associate professor of law. His areas of research and publication include criminal procedure, wrongful convictions, habeas corpus, corporate crime, civil rights, civil procedure, constitutional law, and new forms of public governance. Prior to joining the University of Virginia School of Law faculty, Professor Garrett worked as an associate in New York City at Cochran, Neufeld & Scheck, LLP, litigating wrongful conviction, DNA exoneration, and police brutality cases. He clerked for the Honorable Pierre Laval of the U.S. Court of Appeals for the Second Circuit. I want to thank you all for your willingness to participate in today's hearing. Without objection, your written statements will be placed into the record in their entirety, and we're going to ask that you please limit your oral remarks to 5 minutes. You'll note that we have a lighting system that starts with a green light when your testimony time starts. At 4 minutes, you'll get the yellow warning light that you have about a minute left to conclude your testimony, and then when your 5 minutes has expired, you will see the red light. If you were caught mid-sentence, when the red light comes on, we will naturally allow you to finish your last thought before moving on to our next witness. After each witness has presented his or her testimony, subcommittee members will be permitted to ask questions subject to the 5-minute limit. With that, I would now invite Mr. Attorney General to please begin his oral testimony.
Good morning, and Chairman Conyers and Madam Chairwoman Sanchez and other members of the committee. My written testimony has about 8 points, which I'd like to summarize in my oral remarks now and see if I can get that done in 5 minutes. You've covered point 1, my experience, and I thank you for reminding folks that I served as state auditor, state attorney general, governor of the state, senator, United States senator, serving on committees like Labor and Human Resources, and serving as the Attorney General of the United States. I thank you. Point 2, the public safety effort that we rendered at the Department of Justice is one which is important and should be considered. While most Americans focused on the Department of Justice's record in successfully preventing another attack after September 11th, violent crime dropped to a 30-year low. Teen drug use dropped for the first time in a decade. Gun crime fell to record lows. The department won the largest health care fraud cases in the nation's history. There was a 73% increase in health care fraud recoveries, totaling $4.5 billion. And after the corporate malignancies of the 1990s surfaced, shaking worldwide confidence in our financial markets, we organized the Corporate Fraud Task Force, which reestablished a standard of integrity, restoring America's reputation for sound and secure markets. In dozens of corporate fraud prosecutions, over 600 corporate criminals were convicted, including 31 chief financial officers. Point 3, deferred prosecution agreements protect the American public from corporate criminality while placing the cost of that protection on the corporate wrongdoers, not on the taxpayers. My fellow panel members have written about job loss and functional dislocations of traditional criminal prosecutions destroying entire corporations rather than addressing limited malignancies. In my experience, prosecutors understand that a corporate indictment can be a corporate death sentence. A deferred prosecution can avoid the catastrophic collateral consequences and costs that are associated with corporate conviction. Point 4, as we seek to achieve with other tools in law enforcement, we should constantly seek to improve deferred prosecution agreements. As a result, I welcome and I support the principles announced in the additional guidelines from the Department of Justice. Point 5, as Attorney General, I instructed every U.S. attorney to be, and I did this personally, eyeball to eyeball. I had meetings with each of them, to be blind to the party affiliation and political preferences of individuals. That principle guided my endeavors, including deferred prosecution agreements. It was true then, it should be true now. Partisan consideration should be totally unwelcome in the enforcement of our nation's laws. I learned only last week that during my tenure, more Democrats were appointed as monitors than were Republicans. Partisan affiliation should neither qualify nor disqualify a person from being selected to do public service in the role of a monitor. The focus should be on the quality of service and the results that are expected. Point 6, a monitor should be independent, should demand the highest quality work and the finest professional standards, and be unwavering in the face of pressure. As you may or may not recall, there were plenty of people who attacked me for the way that I chose to defend America from terrorism. Those assaults did not shake my commitment to protect innocent American lives from terrorist attacks. Similarly, a monitor should be immune to pressure and should not allow attacks from whatever sources to contaminate the cause of justice. I will not allow external pressures to compromise my responsibilities as a monitor. Point 7. A monitor protects the public from further corporate abuse. In my case, 5 monitors are charged with reforming an entire industry which is mired in criminal allegations of Medicare fraud and kickbacks to surgeons. There are pending criminal cases against defendant corporations, corporations that have already paid $311 million in civil settlements. There is an active, ongoing criminal investigation into multi-million-dollar payments to physicians that might have altered physicians' judgments about which devices they will implant or prescribe for their patients. A surgeon who makes decisions based on the receipt of illegal kickbacks violates his responsibility to his patients, breaches the public trust, and breaks the law. It must be stopped.
Mr. Ashcroft, your time has expired, but we'll allow you to go ahead and summarize your final point before we move on.
Thank you very much. The marketplace rewards corporations who, from the chaos of contamination, bring the clarity of integrity. On January 29, 2008, Zimmer, for which I am the monitor, publicly announced that it will expand its compliance program to all product lines and all of its global operations, reforms that are well beyond the mandates of the Deferred Prosecution Agreement. After the first full quarter working with our monitoring team, Zimmer reported adjusted net earnings of $276 million, a 28% increase over the previous quarter. Zimmer now projects adjusted net earnings to exceed $1 billion in 2008. Following these announcements, the corporation's market capitalization increased $2.1 billion. The $2.1 billion increase is in direct contrast to the steep market decline in stocks generally this year. The marketplace rewards a commitment to corporate integrity and results. In summary, effective deferred prosecution agreements can protect taxpayers, they can serve the cause of justice, and enhance corporate integrity. And I thank you for the additional.
We thank you for your testimony, Mr. Ashcroft. Mr. Dickinson, I would invite you to provide your testimony at this time.
Thank you, Madam Chairwoman and Mr. Chairman, members of the committee. As you noted, I am a partner in the law firm of Paul Hastings, Janofsky, and Walker. I also serve as an adjunct professor at the University of Michigan Law School and hold a number of bar association and other positions. In addition, I serve as the independent consultant for Monsanto Company and Delta and Pineland Company. I've been in practice for over 25 years and have counseled companies on issues relating to the Foreign Corrupt Practices Act, including DPAs, for my entire career. I also assisted in developing the World Bank's Voluntary Disclosure Program, VDP, and worked with bank staff to advise a VDP participant on improving its compliance program. It's a great pleasure to be here today, and I should state at the outset that I'm here in my personal capacity only and not as a representative of any company, client, law firm, law school, etc. In the interest of time, I will limit my remarks to 3 areas. First, when is a monitor an appropriate component of a deferred prosecution agreement? Second, in such circumstances, how should the monitor be appointed? And third, how should the scope of the monitor's work be determined? To date, no guidelines have been issued outlining the appropriate circumstances for appointment of a monitor as a part of a DPA. This is troubling because of the potential inconsistency and lack of predictability if, in similar circumstances, certain prosecutors insist upon a monitor and others do not. To remedy this concern, I would favor guidance from the Department of Justice that would establish clear criteria for prosecutors to follow when considering the inclusion of a monitor in the terms of a DPA. I would favor the imposition of a monitor under narrow circumstances, such as when a company has elected not to establish a comprehensive compliance program or when there's been a fundamental breakdown in a company's internal controls or compliance program that the company has not adequately addressed itself. Such a standard would leave some flexibility to prosecutors, but would also provide companies with the option to take aggressive remedial actions themselves in lieu of the intrusion of a corporate monitor. With respect to the appointment process, prior to March 7, there were no guidelines. To date, the appointment process appears to be a mix of prosecutor appointments, recommendations, or approvals, as Madam Chair, you noted, but without any particular guidance. While I recognize that some flexibility in the appointment process may be beneficial to the government's objectives, the lack of a defined methodology for the appointment does not, in my view, serve the ultimate government objective of ensuring compliance with the law. I would propose that the appointment process follow a fairly simple formula. First, the company involved in the deferred prosecution would propose to the government its preferred candidate. Such candidate would be required to be clearly qualified in the substantive area of law at issue. As I'm sure everyone is aware, monitors have been utilized in a number of types of cases, including securities fraud, tax issues, export violations, and my field, the Foreign Corrupt Practices Act. It is my view that anyone who a company would propose as its monitor should have the requisite demonstrated expertise such that the government and the public can be assured that the monitor's duties will be carried out in an effective manner. Upon receipt of the company's proposed candidate, I would recommend that the government be given a veto over such appointment should the government believe that the person proposed does not possess the requisite skills or independent integrity to ensure a successful execution of his or her duties. I should point out that this was the formula, or a similar formula, to that which resulted in my own monitorship. Finally, the methodology for establishing the scope of the monitor's work is another topic that might be considered. In order, once again, to ensure a successful monitorship, and I'm mindful that some critics may say that my use of the term successful is by definition, an impossible result to achieve, all parties involved, including the government, should agree at the early stages of any monitorship as to the scope, timing, and budget of the monitor's activities. Of course, adjustments may be appropriate and necessary depending on what transpires during the monitor's terms, and some flexibility must be allowed. This would eliminate some of the uncertainty as to costs of monitors, which need to be factored into a company's analysis for entering into the agreement, and would reduce the potential abuses of monitors. Thus, I would welcome guidelines to be issued by the Justice Department that would set out in a transparent manner when a monitor would be deemed necessary, as well as the methodology to be followed in the appointment process and in defining the scope of work. I would be happy to elaborate my comments. I've included additional comments in my written statement, and thank you very much.
Thank you, Mr. Dickinson. We appreciate your testimony, and you came in right at the 5-minute mark. Very well done. Mr. Nahmais, at this time, I would invite you to provide your testimony.
Thank you, Madam Chairwoman, Ranking Member Cannon, and other distinguished members of the subcommittee. I appreciate the opportunity to discuss the important work of the Justice Department in preventing, deterring, and punishing corporate crime. The investigation and prosecution of corporate crime has been an important priority of the Department since the corporate fraud crisis of 2001 and 2002, and has resulted in more than 1,200 convictions of individuals and entities and the recovery of hundreds of millions of dollars in fines, penalties, and restitution for victims. We recognize, however, that criminal conviction of a corporation, and sometimes even the indictment of a corporation, can have significant collateral consequences for innocent third parties who may include employees, pensioners, shareholders, creditors, customers, and the general public. As set forth in the Department's Principles of Federal Prosecution of Business Organizations, prosecutors properly consider such collateral consequences in determining whether to charge the corporation. Prosecutors may use a variety of tools other than indictment and prosecution to achieve the goal of justice for victims and the public. These tools include deferred prosecution agreements, or DPAs, and non-prosecution agreements, or NPAs. Under these agreements, a corporation against which the government has sufficient evidence to file criminal charges essentially undertakes a period of probation subject to specific conditions by agreement with the government instead of as a result of a criminal conviction that would have substantial collateral consequences. A DPA differs from an NPA in that a DPA typically includes a formal charging document and an agreement that is filed with the court, while in the MPA context there is typically no charging document and the agreement is normally maintained by the parties. Deferred prosecution and non-prosecution agreements occupy an important middle ground in the resolution of corporate crime cases that may have distinct advantages over simply declining prosecution, which may allow a corporate criminal to escape without direct consequences, or charging and convicting a corporation and producing a result that may have calamitous collateral consequences. These agreements typically require the payment of restitution to victims and/or fines and penalties long before such payments could be obtained in most cases through formal charging, protracted litigation, and inevitable appeals. The agreements encourage corporate cooperation in obtaining the evidence necessary to prosecute culpable individuals. Perhaps most importantly, by requiring the adoption of solid internal controls and ethics and compliance programs, the agreements encourage corporations to root out illegal conduct, prevent recidivism, and ensure that they are committed to business practices that meet or exceed applicable legal and regulatory mandates. Thus, these agreements can help restore the integrity and preserve the financial viability of a corporation that had descended into criminal conduct. If the corporation satisfies the obligations imposed by the agreement within a defined period, usually 1 to 5 years, then the government will not proceed with the prosecution. If the corporation materially fails to comply with the agreement, then the government retains the discretion to go forward with prosecution and, in most cases, to use admissions of the corporation to prove the case. Since at least 1992, DPAs and MPAs have been used to resolve a variety of cases involving a wide variety of criminal offenses. But while the use of DPAs and MPAs to resolve such cases has expanded since the fraud crisis early in this decade, it is still a relatively limited practice. Even more limited in number are the DPAs and MPAs that include the use of a corporate monitor. Monitors are independent. They are not employees or agents of the government, and they are not paid with taxpayer funds. Instead, the monitor is retained by the corporation, which pays for the monitor along with all the other costs of implementing the DPA or MPA. The appointment of a monitor is not necessary in every case, but it can have distinct advantages for the public in appropriate cases. Monitors allow the government to verify, through the work of an independent observer, whether a corporation is fulfilling the obligations to which it has agreed. A monitor may also provide specialized expertise to oversee and ensure compliance with complex and technical aspects of a corporate agreement. We believe, as Attorney General Mukasey has previously indicated, that the issuance of additional policy guidance concerning the use of DPAs, MPAs, and monitors will improve consistency and transparency and encourage best practices. As you know, yesterday the Deputy Attorney General issued a set of 9 principles on the selection and use of monitors in corporate deferred and non-prosecution agreements. The first of these principles sets forth a detailed policy on how monitors should be selected, which focuses on ensuring the selection of a respected, highly qualified monitor who is suitable for the particular assignment and free of any conflict of interest. As we go forward, we recognize that we will face new and varied forms of corporate crime. The Justice Department will continue its efforts to develop appropriate policies that provide useful guidance to prosecutors in this area. In doing so, we bear in mind that while public attention may focus on high-profile corporate fraud cases, DPAs, MPAs, and independent monitors have also been used creatively and successfully in other less prominent but equally meaningful corporate crime contexts. It is important that we avoid imposing an inflexible policy that fits one type of case, which may be the unusual type of case, but constrains the ability of federal prosecutors to resolve other types of cases in the best interest of our only client, the citizens of the United States. Thank you.
Thank you, Mr. Nahmais. We appreciate your testimony. At this time, I would invite Mr. Terwilliger to please proceed with your testimony.
Thank you. Chairwoman Sanchez, Ranking.
Can you please turn your mic on? There we go.
Chair Sanchez, Ranking Member Cannon, members of the committee, Mr. Smith, thank you for inviting me to appear before the committee today. The proper handling of cases involving allegations of unlawful conduct by corporations and other businesses is a matter of vital interest to many who are stakeholders in those companies. That includes the people who own them, including the tens of millions of mutual fund owners and other shareholders of public companies, the millions of employees of those companies who depend on these employers for their livelihood, and the countless individuals and other businesses that depend on the goods and services that these companies provide. I appreciate the opportunity to share my views as the committee considers issues concerning business crime and related policies and/or guidelines, which are important to achieving basic fairness by ensuring that like cases are treated alike. The views I offer for your consideration are from the perspective of 30 years of law practice, now divided almost evenly between public service and private practice. At the Justice Department, I began my career as a law clerk while in law school and finished as the acting Attorney General of the United States, and in between dealt with many of these kinds of cases and these issues. I now represent businesses, including corporations, their boards, audit committees, and their leaders as they navigate their way through enforcement matters, including those under the jurisdiction of the Department of Justice. Deferred prosecution agreements provide a middle ground between a criminal and a civil disposition. The company avoids the opprobrium and often considerable adverse collateral consequences that would attend to either a guilty plea to criminal violations or, worse, a conviction after trial, while the government achieves deterrence and punishment objectives without the expenditure of the massive resources and the litigation risks that would be necessary to indict and try such a case. As noted, DPAs often impose an obligation on the company to employ, at its expense, an outside monitor. At its core, the function of an outside corporate monitor is to observe the conduct of a company relevant to its obligations under a DPA and to report the product of those observations, including the monitor's judgment about the company's conduct and its commitment to compliance obligations. Thus, to perform these functions, a monitor should be a person, to borrow a phrase, learned in the law, but as importantly, a person with the background, experience, proven judgment, and integrity to make keen and credible observations and reports concerning the compliance of a given type of business with its legal obligations. Consistent with the government's duty to assure the public that the administration of law is free of any partisan consideration, the process of selecting monitors with these qualifications should be transparent, subject to layered review, and approval at Main Justice in Washington. The selection of monitors should be on the basis of merit and enjoy input from both the government and the subject company. In my own view, since the monitor will be paid for with corporate funds and can provide value to the company in achieving its compliance objectives, the best approach is for the company to select a monitor from a panel of candidates, each of whom has been previously designated as acceptable by the government. I think the Department of Justice has taken an important and valuable step forward by articulating a principled basis for the selection and use of monitors, as it did in its memorandum of March 7th. DPAs often describe the monitor as a compliance consultant. In my judgment, that is a good description of the role of the monitor as both a consultant to a company and as an internal observer of compliance who reports relevant findings to the government. Some go even farther and describe the monitor as being a government representative who is essentially given a seat at the boardroom table. I think this goes too far. Monitors should not have the power to run companies, and those who maintain the responsibility under law, the management and directors of public corporations, should. It is equally important that any guidelines prescribing monitor functions not be dictated by the Congress. Under the separation of powers doctrine, neither Congress nor the judiciary can control the executive branch's exercise of prosecutorial discretion. The decision whether to enter into a DPA or require some other terms in deciding whether to bring charges in the exercise of prosecutorial discretion belongs to the executive branch. I believe the legislation that the committee has considered is not, therefore, well advised. I thank the chair and the subcommittee for allowing me to be heard today and appreciate that my written statement will be included in the record.
Thank you, Mr. Terwilliger. We appreciate your testimony. And at this time, I would invite Professor Garrett to begin his.
Chairwoman Sanchez, Ranking Member.
Could you please turn your microphone on? Thank you.
Chairwoman Sanchez, Ranking Member Cannon, and members of the subcommittee, thank you for the opportunity to testify before you today. I'm an associate professor of law at the University of Virginia School of Law. In 2007, I published an article exploring remedies in deferred and non-prosecution agreements in organizational cases. I will describe these agreements and then discuss two recommendations for reform, guidelines concerning their content, and judicial oversight over their adoption and implementation. First, just to describe an example. In 2007, after a lengthy investigation, the IRS referred a criminal tax case involving KPMG International to the U.S. Attorney's Office for the Southern District of New York. In 2005, prosecutors announced that they had reached a deferred prosecution agreement with KPMG. The settlement stated that if at the end of 14 months prosecutors were satisfied that KPMG had complied with its terms, they would move to have the case dismissed. In the agreement, KPMG provided detailed admissions of wrongdoing. KPMG agreed to shut down its entire private tax practice and to cooperate fully in the investigation of current and former employees. KPMG also agreed to retain an independent monitor for 3 years in order to implement an elaborate compliance program. The monitor was paid by KPMG and had the power to recommend policy changes, obtain access to documents, interview employees, and to employ any personnel necessary. The district judge approved the agreement, and at the end of 14 months, prosecutors moved to dismiss the case, stating the agreement had been effective. However, prosecutions of certain individual KP employees remained ongoing. At least 39 of these prosecution agreements were entered in the 4 years after the Thompson memo was issued in 2003. I've gathered data from the text of these agreements with some difficulty, where several were not readily available. Most resembled the KPMG agreement and involved compliance programs and independent monitors. In preparation for this hearing, I also compiled updated data reflecting 43 agreements entered in the 1 year and 2 months after the McNulty memo was issued in December of 2006. In just slightly more than a year, more agreements are entered than had been entered during the almost 4 years the Thompson memo was in effect. That represents a remarkable acceleration in the use of pre-indictment agreements with organizations. I turn now to reform proposals advanced most recently in legislation drafted by Representative Pallone and in the Statement of Principles authored by Representative Pascrell. First, while the McNulty memo provides useful guidance on whether a firm should be charged at all, scant guidance exists regarding the structure of the remedies included in the agreements themselves or their implementation. The new Morford memo just issued by the DOJ addresses only a very limited set of issues concerning the selection and certain duties of monitors. Much more remains to be done. Several areas are particularly ripe for such guidance. Since 2003, when the Thompson memo was signed, at least 39 agreements included the retention of monitors. Of those, only one advertised an open position to solicit candidates. In only 3 did a court play any role in selecting the monitor. The new Morford memo procedures forbid the unilateral prosecutorial selection of monitors and provide for conflict checks and vetting of monitors by prosecutors. However, those guidelines neither require public notice of a monitor position nor judicial approval, both of which would alleviate any perception of cronyism in the selection of monitors. Many other questions remain. Why do some agreements not require creation of a compliance program? Why do some not include fines or restitution? When are non-prosecution versus deferred prosecution agreements appropriate? Additional guidelines could clarify such issues. Second, judicial oversight of these agreements could provide greater legitimacy by providing a neutral decision maker as well as greater transparency by making aspects of this process public. The U.S. Code requires judicial approval of any deferral of prosecution, but does not address issues unique to the deferral of organizational prosecutions. For example, a court could be required to conduct an approval hearing in which the public or affected parties would have notice and an opportunity to comment, as is the case when certain agencies enter consent decrees. Regarding implementation, when an agreement ends, no information is typically released except the bare fact that prosecutors were satisfied it was successful. The court could publicly report on the monitor's progress. Further, agreements provide prosecutors with unilateral authority to declare a breach and terminate an agreement. A firm may lack any pre-indictment remedy should a prosecutor arbitrarily declare a breach. Courts could be provided with the authority to adjudicate pre-indictment any dispute regarding a breach. Now that pre-indictment agreements have become the preferred method for resolving organizational prosecutions, it's time to consider ways to improve their fairness, transparency, and effectiveness. Prosecution guidelines concerning remedies and increased judicial oversight are warranted to achieve those goals. I'd be pleased to answer any questions that you and your federal committee members may have, and thank you for this opportunity to speak to you.
Thank you, Professor Garrett. We appreciate your testimony. We will now begin our questioning, and I will begin by recognizing myself for 5 minutes of questions. Mr. Ashcroft, do you know who, besides yourself, was considered for the appointment of monitor in the Zimmer case? Or are you familiar with the selection process?
I know what the deferred prosecution agreement provides for in terms of the selection process. It provides that the...
With all due respect, Mr. Ashcroft, I'm just asking if you know how they came to select you as a monitor. I mean, did you just get a phone call one day saying we'd like to consider you for this, or we want you to be the monitor? Can you?
I'd like to answer your question, and so that's about what I was going to do, if you don't mind. I understand that I was selected in accordance with the Deferred Prosecution Agreement after consultation with the company by the U.S. Attorney, and I was asked then to evaluate and to monitor the company's performance. I understand the corporation and the Department of Justice agreed to seek my service during the course of their discussions over the Deferred Prosecution Agreement, so in the course of their discussions.
Do you know if they considered anybody else for the position of monitor?
I don't know what kinds of discussions they had.
Okay, that's fair.
I wasn't part of those discussions.
Okay.
I learned about this after they had the discussions.
I understand. That answers my question. Do you know whether there was any public notice or bidding prior to your appointment?
I did not participate in any bidding. Not a single cent of tax dollars is spent for monitors.
I understand that, but that's not the question that I'm asking, though. I'm just trying to get through the very basics.
This hearing costs far more in tax dollars than my monitorship will cost in tax dollars, because not a thin dime of public money.
I understand that, but the subject of the financing is not what I'm trying to ask you.
Sure, go ahead.
Just trying to get some very basic questions out of the way.
I would like to get some very basic answers, because your original remarks made a series of accusations. I'd like to get to those so that I can answer them and clarify this situation.
Okay, well, if you'll allow me to ask my questions, we'll have many other questions from the panel, I'm sure. In your view, would the monitor selection process in the Zimmer case comply with the guidance that was issued publicly by the department yesterday? Or have you had a chance to review those
I have
guidance?
Reviewed them very briefly. They were made available to me late yesterday afternoon. I believe it would have been very possible that I could have been chosen under the kinds of guidelines. I would hope so. Let me say, as I said in my remarks, I don't think there should be a discrimination against individuals who have had the privilege of public service. I don't think there should be a discrimination against people on the basis of their partisan identification. And I would certainly hope that whatever guidelines would be promulgated by this Justice Department or encouraged by this Congress, that they wouldn't discriminate against individuals whose qualifications are those like mine are.
Okay, well, Mr. Ashcroft, on that issue, I'd like to call your attention to the fact that the guidance issued yesterday indicated, and I'm quoting from the guidance, government attorneys who participate in the process of selecting a monitor shall be mindful of their obligation to comply with the conflict of interest guidelines set forth in 18 U.S.C. Section 208 and 5 CFR Part 2635. So the question that I want to get at, which I think is part of the problem, and we've heard from several witnesses talk about no conflict of interest, is do you believe that Mr. Christie violated any laws or regulations already in the books when he appointed you, his former employer, as a monitor in the Zimmer case?
I really don't believe that Mr. Christie is a law violator. His
so
record
you don't believe
as
that
a prosecutor is an outstanding record. No law that I know of has been violated, and I don't think there's an even plausible suggestion that any has been violated.
Do you, and you don't believe that there's a problem?
His reputation
you don't believe,
prosecuting public corruption.
You don't believe that there's,
and for this committee to attack him.
I'm not attacking his record of prosecution.
As a matter of fact,
I'm talking specifically about the issue of conflict of interest. Mr. Ashcroft is very interesting about his record, and we're not attacking his record of prosecution. We happen to be talking specifically about conflict of interest. That's a very appropriate question for this hearing. This is what we are trying to get at. The crux of the problem is either conflict of interest or at least the appearance of conflict of interest. And if I'm hearing your testimony correctly, would it be fair to say that you don't believe there's any kind of conflict of interest in a former employee hiring their former boss or suggesting that he be hired for a very lucrative contract of monitoring? You don't believe that there's a conflict or a problem with an appearance of a conflict of interest?
There is not a conflict. There is not an appearance of a conflict. The ability to hire individuals who have the qualifications to conduct monitorships should not be impeded by the fact that someone at some time or another served in public life or public office. It should not be impeded based on partisan grounds. It should not be determinative or dispositive in the Justice Department, and it shouldn't be equally dispositive or determinative here in the Judiciary Committee of the United States House of Representatives.
Very interesting answer, Mr. Ashcroft. My time has expired. At this time, I would recognize Mr. Cannon for 5 minutes of questioning.
Madam Chair, I'd prefer to pass if that is acceptable to you, but would like to introduce for the record an article in the record that I think Mr. Ashcroft was just referring to about Christie's all-out war, and which includes this rather remarkable list of successful prosecutions, and point out that you keep referring to the problem. I think that we have an issue before us that we need to manage and develop, but I don't think there is a problem, especially when it comes down to Mr. Ashcroft's character and record on his own, or Mr. Christie's.
Will the gentleman yield?
Thank you. Actually, let me just defer my time, if you don't mind, but I'd be happy to. I think the chair actually would control the time and could speak directly.
Well, without objection, the article will be entered into the record, and the point that I was trying to get at is the public confidence in our justice system and whether or not conflicts of interest, actual or perceived, are a problem in terms of a perceived problem in terms of the public's confidence in our justice system. And
if the chair would yield.
I will yield.
This is a remarkably important issue, and we have an amazing panel. And on that panel, we have a guy who is lionized in America for his willful determination to not sign a memorandum on his, some people call it his deathbed. Certainly it was a very ill bed. And to say there is a problem related to him is one that I think ought to be squarely confronted. I know that we have two witnesses on the next panel who are representatives from New Jersey who want to attack Mr. Christie, and I understand the urge to attack Mr. Ashcroft's credibility. I find it appalling.
Well, the gentleman, I was not attacking Mr. Ashcroft's credibility. I was simply posing a question with respect to
You are questioning his integrity and calling it a problem.
Well, if there is a conflict of interest, I would submit that's a problem.
When you get the list of people who were capable of doing the job that needed to be done at Zimmer, I think it was a remarkably short list, and the people that appear on a list like that are going to be people that have relationships, and therefore you can never get beyond the problem. I think the proper scope of this committee is to actually oversee these monitors. I think that's an appropriate role, and I think we need a lot more staff in this committee to do that. But right now, I think we ought to be looking at policy rather than creating the question of a problem when you're talking about a man of such distinguished history and unquestioned ethics as Mr. Ashcroft.
The gentleman will yield back. I will recognize Mr. Johnson for 5 minutes of questions. Mr. Johnson.
Thank you, Madam Chair. And during 27 years of practicing law back home in DeKalb County, Georgia, I represented many people, and they were all just regular working class people, blue-collar folks, and they were all subject to the maxim of you do the crime, you do the crime, you do the time. And so now today I'm here hearing about non-prosecution agreements with corporations and also deferred prosecution agreements. And if there were any deferred prosecution, it would be something for my clients that they would have to appear in court and face the charge and admit to the allegations and ask the judge for some consideration. And the judge, in his discretion, his or her discretion, would decide whether or not that person would be placed in a non or in a deferred prosecution program. And we don't have any of those kinds of qualities that exist or that existed for these prosecution agreements here. But I do want to ask Mr. Ashcroft, while appreciating your service to the nation, according to billing records that detail 5 months of work from September 2007 to January 2008, your firm has billed Zimmer Incorporated more than $7.5 million
over these 5 months, your total fees are higher than the other than other monitors, particularly the 4 other monitors for the 4 other orthopedic device makers who entered into deferred or non-prosecution agreements with the Justice Department. Your firm is the only one of the group that charges a set monthly fee of $750,000 on top of your hourly billing rate, which is also the highest of the 5 firms, topping out at $895 an hour. To your knowledge, are you aware of any monitors charging a monthly fee of $750,000 on top of a $895 hourly billing rate, Mr. Ashcroft?
Well, we do not charge both an hourly fee, and the hourly fee covers one group of workers. Other individuals are covered in the set amount, and they are not working on an hourly basis. The reason our fees are appropriate is the complexity of the case and the responsibilities in which we have to be involved. I've been required to assemble an exceptional monitoring team of about 30 professionals, including lawyers, investigators, accountants, other business consultants, to ensure that the deferred prosecution agreement is met. These professionals include former United States attorneys, assistant United States attorneys, former FBI members, former United States Department of Justice officials, intellectual property lawyers.
You've answered my question. You've got a high-powered and highly paid staff that consumes that monthly retainer fee. Now, for each monthly billing period, all that you have provided is a one-page bill that simply lists the total amount due and the bank information about where to wire the money, whereas other firms would have submitted bills, detailed billing, 200 pages long, for instance, or 78 pages long. Why don't you provide Zimmer with a detailed accounting explaining the services provided and the monitoring expenses?
Well, we believe that the quality of the services is the important point, and that we have agreed and provided information about our fees in advance.
Will you provide this committee with a detailed accounting of the services provided and expenses incurred in the Zimmer monitoring?
I will provide this committee with the documents that are required under the Deferred Prosecution Agreement, and I will make available to the committee those items which are required by that agreement.
Who is tasked with monitoring the monitor? In other words, who ensures that you complete all of your responsibilities under the Deferred Prosecution Agreement?
First of all, the company has an opportunity to raise issues if it finds the work of the monitor to be inappropriate, insufficient, of low quality, or finds directions of the monitor to somehow to be against what it considers to be the terms of the agreement, outside the scope of the agreement, or otherwise inconsistent with the purposes of the corporation in remediating the problems that are faced by the corporation. The company carries those items to the U.S. Attorney or to the Office of the U.S. Attorney, to individuals in the office who are involved in the administration of the Deferred Prosecution Agreement.
The time of the gentleman has expired. At this time, I would recognize Mr. Feeney for 5 minutes of questions.
Well, thank you, Madam Chairman. Mr. Attorney General, it's great to see you back. The startling thing for me here is all of the suggestion or innuendos, the mere implication of having the hearing today that there is some either conflict or something fundamentally wrong, and we're worried about the costs to corporations. I have to be candid with you. The Congress voted overwhelmingly a few years ago for a bill that's commonly referred to as SOX, Sarbanes-Oxley. And what Sarbanes-Oxley effectively did, Mr. Ashcroft, whose firm has been charged with monitoring a corporation where several individuals and perhaps the corporate entity itself may have been indicted or convicted of a crime, to keep it alive and protect it despite the wrongdoing. What Sarbanes-Oxley has done is effectively to take every innocent corporation that wants to go public in America and require them to spend about $6 million annually at the requirement of Congress to pay additional accounting fees on top of the accountants that they already have. I can't get members of the majority party to be concerned about the fact that Sarbanes-Oxley cost the United States economy, according to one study done by a professor from the Brookings Institute and another professor from the American Enterprise Institute. They estimate the annual cost, superfluous and unnecessary costs of accounting that bill, cost the American economy $1.4 trillion. And yet and that's for innocent corporations that have done no wrong. And yet when you have a corporation, some of whose leaders have actually committed crimes, you have a couple choices. You can, in effect, give that corporation the death penalty, even though the overwhelming majority of individual employees, partners, maybe even members of the board of directors, and certainly the shareholders were totally innocent of any wrongdoing. So as Congress is continually battering and punishing the innocent because of the faults of the few, now we're here suggesting that there's something fundamentally wrong with hiring perhaps the most qualified individual in the country on health care and matters of jurisprudence from the Attorney General's perspective. There's something fundamentally wrong about giving a company and its shareholders and the innocent employees and the innocent members of the board and the innocent partners a second chance. I don't know how many innocent people worked for Arthur Andersen when it was given the death penalty. Perhaps it was a prudent thing to do to punish all of the innocent along with the few of the guilty. But it didn't help the American accounting system very much. As a consequence of Sarbanes-Oxley, we now have only 4 corporations in America willing to do the type of work that is required by Sarbanes-Oxley, and so you have a quadropoly where they get to charge whatever they want to, and every corporation in America has to pay the price. Presumably, if you're, for example, Pepsi, and you have an inside auditor, and your major competitor, Coca-Cola, has one inside auditor and has to hire one of the other big 4 outside, there's only one left, and you have to do business whatever the cost. The indirect costs have totaled, according to this one estimate, $1.4 trillion for innocent American companies. And as capital flees America, we are outsourcing our 100-year lead to places like London's stock market that advertises itself as a SOX-free zone, the Frankfurt market, the Hong Kong market. We've done this to ourselves, and we're happy about it. And yet we find a situation where we're giving a company and the innocent people that are affiliated with it a second chance, and most importantly, the shareholders. And we are here today battering people that are trying to save a company and giving it a second chance. I just find it remarkable. There's no situation in America that Congress can't make worse. And I think the hearing today is a great example of that. With that, I don't have any questions. I guess I've got an opinion already on this subject. I'll yield back the balance of my time.
The gentleman yields back, and at this time, I would recognize Mr. Delahunt for 5 minutes of questions.
Well, I thank my friend from Florida for the exposition of Sarbanes-Oxley. I would suggest that Enron had more to do with it than Sarbanes-Oxley. We're talking about confidence here, and I think that Congress, in its wisdom, in its bipartisan wisdom, decided that if investors were going to have confidence in our free market system and free enterprise, that something had to be done in terms of accountability. And maybe we're seeing that again in terms of the so-called subprime crisis that has generated a tremendous magnitude, if you will, of economic pain as witnessed by the plummeting stock markets. But having said that, I'm certainly not interested in discrimination against individuals who have served in government at whatever level. I don't think there should be any discrimination, and I don't think that General Ashcroft is the import of today's hearing. Again, to echo the observations by the chair, I think it's a question of confidence in the integrity of the system. Not your personal integrity, not the personal integrity of anyone here at the panel, because we know it does count. Because while there are no taxpayer dollars involved, this is, if you will, a fine being levied on a company that could have presumably been indicted. Really what is occurring here is a monitorship is performing a public function, a function that is a key element in terms of assuring the American people that justice is being done. I am a believer in prosecutorial discretion and judicial discretion. That's why I vote against mandatory sentences. But I do believe in sentencing guidelines and transparency, and what I would suggest is what we have here is a situation that doesn't provide the kind of transparency and raises issues, and legitimately raises issues that ought to be addressed. General Ashcroft, you heard the testimony of Professor Garrett. Would you make any comments in terms of those policy issues that he raised in his testimony regarding guidelines, transparency, accountability? Because whatever, I was shocked, to be perfectly candid, that this company, Zimmer, was consulted about whether you were acceptable. I find that remarkable. There ought to be something better than receiving the imprimatur of a corporation that I would suspect was involved in significant wrongdoing, and asking whether it's okay if former Attorney General Ashcroft leads a monitoring team. That was stunning to me. What I suggest is there ought to be a good hard look at what the guidelines are, what we have in terms of transparency and accountability. I haven't had a chance yet to read the legislation proposed by my good friends from New Jersey, but something ought to be done. General?
Well, thank you very much. First of all, I don't believe that the monitorship is a fine. I think the monitorship is a way to say that because there's an agreed upon area where the law has not been respected in the way that the system believes it should be, that there should be a way to remediate that. And trusting the person who has been a wrongdoer to remediate that on his own is inappropriate. In our case, and this is public information because I'm not here to discuss things that aren't public about the case or to telegraph where the investigation may go or not go, and there are real serious problems with having open hearings about ongoing criminal investigations. And this is an ongoing criminal investigation that relates not just to one company,
I understand that, General,
but to 5 different companies that comprise 95% of the orthopedic joint replacement industry. But in the industry, consulting contracts were used as a cover for kickbacks to doctors. So a doctor implanting a device like an artificial knee or hip might have his decision clouded by the fact that if he implanted one, it would be in the interest of his wallet, whereas if he implanted another, it would be in the interest of the patient.
General, with all due respect, my question went to the recommendations.
Yes.
And maybe you didn't have an opportunity to
well, what I'm saying is
hear them closely, because what I suspect in terms of how appointments are made, when reports ought to be filed, when things ought to be made public, would fall within appropriate discretion of a court, of maybe a probation service, because I think that there could be a way to achieve the goals of those members who have expressed concern about this and a public I mean, the reality is you are the former Attorney General. In some ways that's helpful. In some ways it's a burden that you will always carry. I was a former district attorney, and I have 70 former assistants that are currently serving on the Massachusetts bench. I know that half of them would recuse themselves if I simply came before them and argued a case, although there is no conflict, but appearances do count. And I think that's got to be factored into the equation.
May I?
The time of the gentleman has expired. At this time, I would invite...
Is the chair going to let the Attorney General respond?
Briefly.
I would just say I have read a number of the professor's articles. He's a prolific author and a valuable contributor in raising the questions that ought to be discussed. I was attentive to Councilor Terwilliger's remarks that raised the issues that relate to the separation of powers. And I think that the decisions as a former prosecutor you would agree to prosecute or not to prosecute are appropriately vested in a way in a separate branch of government. The idea that you might have people in the judicial branch making decisions about whether or not to prosecute cases that they later sit in judgment on has serious, there are serious drawbacks to that. I noted that when the professor has addressed these items, he's tried to avoid those kinds of problems with the separation of powers. And any approach to this ought to be very tenderly undertaken with a view to the respect of not having the judge and the prosecutor be sourced in the same part of the governmental system. Now, I need to give my thanks to the committee. When you scheduled this, I indicated to you that I had a speaking responsibility in Central Florida this evening and that I had a 12:50 flight at Dulles. And so I intend to leave in accordance with our previously agreed to scheduling, and I thank you for your understanding of that. I'm grateful to you, and I want to thank each of these thoughtful individuals who has participated. And I think in my absence, your ability to discuss the real issues here and not to be bogged down in a specific case, which would be inappropriate in any event, will be enhanced. Thank you very much.
Thank you for your testimony, Mr. Ashcroft. We appreciate you coming today, and we wish you luck in catching your flight. You are excused.
Madam Chair.
Congressional unity on the highway.
Madam Chair.
I don't know that congressional immunity actually exists for anything. If it does, I'm not aware of it. Who seeks recognition? Mr. Franks.
Yeah, Madam Chair, the General Ashcroft is leaving. I guess I wish that he could have been here for my own comments just related to the gentleman's reputation in this country for personal integrity. I think that he represents the kind of public servant that a lot of us would like to be when we grow up. Other than a few partisan members of Congress, it occurs to me that what is at stake here to this company, to Zimmer, one of the reasons I think they wanted someone like Mr. Ashcroft to be involved in this agreement was simply because they knew that his reputation was such that if indeed he entered into it, that he would do so and would expand that commitment to integrity to their company. And, you know, in all respect to Mr. Delahunt's concerns, if I were on the board of this company and the guilty members had been expunged from the company, I was doing everything that I could to restore this company not only to profitability, but to coming in compliance with the law and being a company that the stockholders could aspire to. I would do everything I could to bring a man like General Ashcroft into the equation. It makes all the sense in the world to me, and certainly the result in the company's profitability and in their credibility, the change that took place in this company, I think, is partly something that we can lay at Mr. Ashcroft's feet. And
if the gentleman would yield,
certainly.
He referenced me. I think that we have a larger obligation. I'm not in any way questioning the credentials of the former Attorney General, but I dare say there are major law firms all over this country that could perform the kind of services necessary. that have people of high profile with bona fides that are impeccable. But when you have a potential wrongdoer, which is the corporate entity, requesting or signing off on who is going to monitor compliance with the agreement, I would suggest that the public says, what's going on?
Well, reclaiming my time, keep in mind there's two parties to the agreement. That's the company and the prosecutors, and they're trying to find someone who can be acceptable to both of them and to present to the public a credible image. And I think General Ashcroft does that in a way that very few people can. I mean, this gentleman's been the Attorney General of Missouri, Missouri's chief auditor. Let me finish. I'm about out of time. His chief auditor, the governor of Missouri, U.S. Senator from Missouri, the Attorney General of the United States. And I don't know how you could find someone that more personifies the perfect example of what someone in this capacity, what qualifications they should have.
If again, my friend would yield for just a moment, I think that we all approve, as the ranking member indicated, of the former Attorney General's courage in the face of the pressures that came from the White House in the form of Mr. Card
reclaiming my time.
And former Attorney General Gonzalez to get him to
reclaiming my time, Madam Chair.
Well, I'll yield back.
Pardon me, the time belongs to the gentleman from Arizona.
Madam Chair, I mean, if we're going to deviate into these other situations, if Mr. Ashcroft is an example here of what's wrong with the system, where is Mr. Torricelli? Where is Mr. Stryker? If we're going to deviate off here, this is a bad example to use someone like General Ashcroft as to what's wrong with the system, and I think that that's been done here to a degree. And I just wonder, if the public realizes that he had nothing to do with the prescribed DPA, or he didn't negotiate the terms with the company in any way, and the fee arrangements he didn't negotiate with the company in either way, and yet these things have been previously not released publicly, and I'm wondering how the fee arrangements were made public in this situation. And I'm about out of time, so I will now yield back to Mr. Delahunt.
Well, I thank my friend.
Yields back his time.
Yeah, and there's still some time on the clock, I see, Madam Chair, but
yes, but
I wanted to respond that I wasn't being.
Does the gentleman seek unanimous consent for 30 seconds?
Madam Chair, I've yielded my time to the gentleman.
You've yielded. I'm sorry, I misunderstood. The gentleman from Arizona has yielded the remainder of his time to Mr. Delahunt. Mr. Delahunt is recognized.
Thank you, Madam Chair. I wasn't deviating. I was making a point that was brought up by Mr. Cannon, the ranking member, about the credentials. The credentials in terms of his political courage to stand up against the White House, against the then counsel to the White House, Mr. Gonzalez, and to support Mr. Comey in what I consider an act of political courage. But my point is, it's about appearances and the confidence of the American people in the system. No one here is questioning his morals, his ethics. It's what about the perception of a fee that I'm just reading ranges from $28 to $57 million. That's a lot of money. Now, I'm all in favor of lawyers making money. That's something that I have fought for all my life. And I have to tell you, I'm glad to hear that we can agree on that, because in the past, it has been the then majority, now minority, that have argued for capping lawyers' fees when it came to class action suits. So I'm glad that we've adjusted our sights and are now moving forward. And I thank my friend for yielding and yield back.
The time of the gentleman has expired. At this time, I would recognize Mr. Cannon, who chose to pass, for 3 minutes of time. Mr. Cannon.
Thank you, Madam Chair, and I expect to ask unanimous consent for an additional 2 when we get to that point. But I'm a little confused by this last exchange. We're talking about the courage of a man and his willingness to stand up and do the right thing, but somehow making a distinction between his courage and his credentials. I think that there is probably not a lawyer in America who has the credentials that Mr. Ashcroft has. The amazing thing about this hearing so far is we have this really incredible panel that could inform us on where we need to go, and virtually every single question on the Democratic side has been about raising the question of the problem of the perception of a conflict of interest.
Will the gentleman yield?
Yes, I will. Briefly.
We will be, and you will be granted additional time, I assure you. We will be moving on to a second round of questions, and I assure you there will be many questions that we will have for our remaining witnesses. I think our asking Mr. Ashcroft questions first was due to the time constraints. We knew he would not be here
Reclaiming
for the
my
remainder
time.
of the
These were not questions the majority was asking, Mr. Ashcroft. These were veiled charges. This is all about innuendo. And the fact is, did this committee do an open bidding process for Mr. Irv Nathan's services, for instance? The fact is, and as the chair knows, I've been a big supporter of Mr. Nathan and what his current job, but we didn't do it with a bidding process for a very good reason. And I think that, we've sort of exhausted that. No, I think we've sort of exhausted that issue with the Attorney General. Now, if I might, I would like to actually turn to the panel and see if we can rekindle the discussion, which I think is absolutely fascinating. And so I'm going to ask two general questions that I'd like the panel to respond to. Mr. Garrett said something to the effect of much more remains to be done with respect to guidelines. We have memos, 3 memos now. We have some guidelines that have been developed. And if I can just give these two questions to the panel, I won't ask for additional time, Madam Chair. But first of all, where do we go? Are we done with these guidelines? I think the answer is no, but where do we go with new guidelines? And then could each of you also address that? And then secondarily, address the issue of oversight. Should courts oversee monitors, or should Congress oversee monitors? We have a vast issue of separation of powers, and I'd very much like to have your opinions on those two issues. We may start with Mr. Dickinson.
Mr. Dickinson?
Thank you. On your first point, where are we going? I think I would certainly hope that we're going with more guidelines from the Justice Department. I think we have a very, very good start with the guidelines that came out yesterday on the appointment process. I would still like to see, as I said in my remarks, the criteria in which a monitor should be appointed. That's an area where we still do not have any guidelines. And I think the work scope was the third area that I mentioned, and one that perhaps should also be considered. But I think we definitely need some guidance as to when a monitor will or will not be incorporated into a DPA. With respect to the oversight, it's my view that the oversight should come from the Department of Justice in conjunction with the DPA and the prosecutor and the entities involved with the negotiated DPA itself. And I think that I've proposed that there should be periodic meetings. There should be a discussion between both the government, the monitor, and the company involved, all three of them throughout the monitorship period, which would allow all parties to discuss and understand the status of the monitorship, issues that arise, and how anything that has arisen should be resolved. So, and remember that these are not just for the typical criminal things that we're talking about today. These issues arise in the tax fora, in export laws. There are a variety of issues that may require a monitorship. So I think that the government expertise in this area should also be brought to bear in the oversight.
So if justice continues to do oversight, then this committee oversees justice.
Correct.
Mr. Nahmais, and if pardon me, if the witnesses could please keep their answers brief, because we are running over.
Well, I think it's useful to understand that we started really around the 5-year anniversary of the President's Corporate Fraud Task Force to realize that we had accumulated enough of an experience base with these types of agreements across the country and at Maine Justice to start developing the type of best practices and guidance that we recognize is important in this area. There is some guidance, and we have started this process with the issuance of the criteria on selection and use of monitors that came out on the 7th. One of the things that has struck me in working on developing this guidance is I had a perspective from my time at Maine Justice seeing many of these large corporate fraud, Fortune 500 type cases. You have a very different perspective when you're in the field, where a lot of the cases that involve these issues are not of that type, do not involve those types of offenses, and even more so when I talk to my colleagues as we develop policy and find out from them, yeah, what appears to be a good policy will either need an exception or some recognition of the fact that there are very legitimate prosecutorial reasons in another case that need to be taken into account. I think it is our view that this is an area that we need to continue to study. We are interested in input, obviously, from all sources, including the Congress, and we'll take that into account as we go forward. We'd like to have a chance to see how these guidelines that have come out work. On the issue of when a monitor should be used, while that is not fully spelled out, there are indications in the policy that came out this week that of the types of considerations that should be taken into account in deciding whether a monitor should be used. And there are also some guidance in the principles on the type of scope of work that a monitor should be considered for. With regard to the issue of oversight, it's important to distinguish between deferred prosecution agreements, which are filed with a court. Both the charging document and the agreement is taken to a magistrate judge or a district judge who has to approve the deferral. So there is court approval of that deferral. There, as Mr. Ashcroft was saying, there are concerns about the court getting more enmeshed in the details of approving these agreements, which are agreements not to seek a indictment and final conviction of a corporation. Courts generally do not get involved in that area. I think Professor Garrett has talked about some court involvement, but that is in the civil settlement context of consent decrees. In the criminal prosecution discretion area, the prosecutorial discretion is very important, and the concern about intrusion by the other branches of government is, I think, heightened. With regard to congressional involvement, the same issues arise. The principles for our exercise of prosecutorial discretion have typically been developed within the Justice Department, often seeking input from various sources, but those are kind of core prosecutorial discretion functions, and I think there would be some fairly significant separation of powers issues if one of the other branches of government was too enmeshed in the exercise of who should be charged.
Mr. Terwilliger, and I hate to do this to you, the last two witnesses, but considerable amount of time was given in the first two witnesses' response to these two questions. I would please encourage you to be brief in your answers to the two questions Mr. Cannon posed.
Thank you. In terms of where it goes from here, I want to commend the committee for having this hearing, at least insofar as the focus is on the use of these kinds of agreements, because from my client's perspective, that is the business community, some focus on these issues is critically important. The guidelines the department issued, I think, are a very, very positive step forward in bringing some level of policy guidance and structure to the use of DPAs and, in turn, the use of monitor arrangements within DPAs. I do think, however, just based on the comments that have come from the members at this hearing today, there is not yet a common understanding of what purpose a monitor serves and what purpose a monitor serves within the larger context of a DPA and what the use of a DPA is in terms of an alternative disposition method. And I think it would be well worth the time of the committee to continue to look at that and look at that as an oversight matter in terms of how the Justice Department approaches that. In terms of oversight, courts have not proven to be very adept at running prisons, running school systems, and I don't think they would be very adept at running corporations through monitors. So while the courts have a role, it is a limited role in a criminal disposition involving any defendant, including a corporation. The responsibility for seeing to it that DPAs achieve their remedial purposes vis-a-vis corporate behavior rests with the Justice Department, and this committee clearly has a role in oversight to determine that the Justice Department is in turn meeting that responsibility.
Thank you. Professor Garrett.
Just briefly,
please turn your microphone on.
Oh, I'm sorry. So I think it's a wonderful development that the department is exploring best practices in this area. And there is a sufficient body of these agreements and experience with them that I think this is an important time to be doing that. It's hard for outsiders, like a law professor, to study these agreements with so little information available. It's hard to even get the text of some of them. I think at minimum, for the public to be able to evaluate what's going on, we would need to know who are these monitors. It's hard to find out their names, much less the terms of their retention. A court could, at minimum, even if it's not engaged in intrusive review of the work of a monitor, could ensure some transparency so that we know that what the reports are, or some version of what the implementation is. I think it's important to distinguish between the remedies and the implementation of these agreements from the charging discretion of the prosecutors. Courts could be involved in the implementation of the agreements or in just minimally approving the remedies, as they do now under the U.S. Code if it's a deferred prosecution agreement. I think we should be more concerned about non-prosecution agreements in which the court has no role. I think those are it's troubling to proceed in that fashion, and many practitioners have complained that there's little difference between the sorts of situations in which a non-prosecution agreement is entered versus a deferred prosecution agreement. I would just finally point out that if a company is convicted and is placed in corporate probation, a court could very much supervise compliance or supervise a monitor. It's not unheard of. It's something that the sentencing guidelines provide for. So this is not a new role for courts, and it's something worth thinking about.
Thank you. There is interest.
Thank you, Madam Chair, and I yield back.
I thank the gentleman for yielding back time, which he does not possess. There is sufficient interest in a second round of questions, so I hope the witnesses will bear with. These are sort of cleanup questions that hopefully will enlighten us further before we move on to our second panel. So I will recognize myself for 5 minutes of questions, and I will begin with Mr. Dickinson. I'm interested in knowing, in your opinion or in your professional experience, to whom do you think that independent monitors owe duties? Are they owed to the prosecutor? Are they owed to the corporation? Can you enlighten us a little bit on that?
It's a very good question, and I think a very difficult one to respond to. I notice in the Justice Department guidelines they state that the monitor does not have a responsibility to shareholders. I believe that the monitor really has a responsibility to all the parties involved, and indeed is appointed for their independent expertise and their independent capability to assess both sides of the coin. They are brought into a matter after a problem has occurred. They are given a mandate. I would hope that the written structure of the DPA would actually inform the monitor as to those duties. Some monitors may in fact be required to report to the Justice Department. Some are not. Some are actually instructed to report on additional issues that arise. Some are not. These are the types of things that Mr. Nahmais has pointed out. I think the Justice Department is getting better at and needs to refine more. As a short answer.
Thank you. And I'm interested in asking you, according to the Washington Post, Mr. Ashcroft had to use considerable time to prepare for the assignment and learn more about the business before he became the monitor in the Zimmer case. And I noticed that both you and Professor Garrett emphasized in your testimony that the person selected have the requisite background, expertise, skills, and integrity in order to fulfill that role. In your view, should a monitor have to use considerable time to prepare for a monitoring assignment, or do you think that they should essentially be ready to hit the ground running when they are appointed?
I think they should be ready to hit the ground with respect to the substantive law at issue. I think it is only appropriate to appoint a monitor that has substantive expertise in the issue that has arisen that is the underlying issue of the problem. With respect to the business, however, I think it's very fair and vital that the monitor come in and understand both the background of the problem and the industry in which the monitor is to work.
Madam Chair, may I address that just briefly?
Certainly.
My law firm, my practice group, has conducted worldwide compliance reviews for companies, looking where they go voluntarily to look at their own conduct and ascertain the level of compliance that exists in their international operations. It is absolutely essential and really expensive that the lawyers spend the time on the front end of that process understanding exactly what that business is and how it's conducted, because otherwise you don't know where to look for where the problems might be.
Certainly, but you would also agree, would you not, with Mr. Dickinson, that the selected monitor should have the requisite experience in that field of law
Yes.
so that they can hit the ground running.
Certainly
so to speak.
in that field of law, but my point is slightly different. and
I
that is
understand.
that
There are
understanding the
two different
business is important.
Absolutely. There are two different types of experience one would hope that the monitor would have, and both are important. I'm interested in asking Mr. Nahmais, in the agreement deferring prosecution of Bristol-Myers Squibb, U.S. Attorney Christopher Christie inserted a provision requiring Bristol-Myers Squibb to endow a chair in business ethics at Mr. Christie's alma mater, Seton Hall. I'm interested in knowing, why was that provision inserted into the Bristol-Myers Squibb's agreement, and do you think it's appropriate type of thing to include into a deferred prosecution agreement?
Well,
I'm a little puzzled by that, to be honest with you.
This is an area that some people refer to as extraordinary restitution, the payment by a defendant or putative defendant to a third party. It is not an unusual occurrence for defendants, individuals, or corporations to do that in an effort to seek leniency with a court. The issues arise when the government has some involvement in it. It's actually an area that is worthy of further consideration by the department. With regard to the matter you're referring to in the Bristol-Squibb-Myers case, my understanding is that idea was actually raised by counsel for Bristol-Squibb-Myers, not by the U.S. Attorney's Office.
But would that not be a way to sort of curry favor with the prosecutor who's deciding whether or not they want to charge this defendant?
Well,
I mean, don't you think that creates this either conflict or potential conflict?
When it was raised, the only request by the U.S. Attorney's Office is that it be at a law school in New Jersey, where the district is. My understanding is that Bristol-Squibb-Myers initially approached Rutgers Law School, which is not Mr. Christie's alma mater, and found out they already had a chair in business ethics, and only after they determined that they weren't going to go to Rutgers did they go to Seton Hall. These arrangements...
But do you think that those types of extraordinary measures that get inserted, there probably should be some kind of guidance?
This is an area I believe is worthy of further guidance, and I think the department is committed to looking into that area, hopefully in the near future, to establish some guidelines. Again, it's the kind of area that has occurred in both individual cases and corporate cases across the country for years, and we're reaching a point that we think we have the experience and the best practices to form the kind of policy guidance that could be useful.
I think you would be well advised to actually develop that guidance. My time has expired. Mr. Cannon is recognized for 5 minutes.
Thank you, Madam Chair. This has been interesting, and I appreciate the discussion we've had about deferred prosecution agreements, and in particular your answers on who should oversee that process. And I think that we have a consensus on the panel that should be done at DOJ, the Department of Justice, with oversight by Congress, which would mean this committee, the Committee on Commercial and Administrative Law, which has the jurisdiction within the Judiciary Committee of the House to oversee the U.S. attorneys. I'd like to expand the idea of oversight of prosecutorial discretion a little bit and give you a couple of quick cases and then get your response to what ought to happen. We had a very famous case in Salt Lake City over the Olympic Committee when the the first organizers of the Salt Lake Olympic Committee were charged with a crime. I just couldn't understand, as a simple country lawyer who actually didn't do much criminal law, but I couldn't figure out where the crime would be. And then after 5 years and a torturous time and millions of dollars in defense fees, and by the way, in the middle of all that, the judge had dropped a number of the charges, and that was an appropriate time, I thought, to ask the Department of Justice to review the case. But there's really no other place where a congressman or a senator or anyone could actually suggest to a prosecutor that maybe there wasn't substance to the case. And then ultimately the case was presented, and we heard a pathetic plea by the prosecutor to the judge, who was on his own motion going to dismiss the case, that the prosecutor's plea was to the judge to let the jury inform the judge's conscience. And the judge says, the jury can't inform my conscience. As a matter of law, you didn't make your case and dismiss the case. We had another similar case where in Utah, where the FTC had prosecuted a guy, and during the whole course of the prosecution, they demanded his his financial statements. He said, my financial situation is sort of complex. If I give you my financial statements and then the reality turns out to be different and I've signed those financial statements, then you'll prosecute me for lying. And they said, yes. So he said, why don't we just decide what the penalty is that you want, and I'll pay the penalty. And they said, no, we want your financial statements because we're going to determine the penalty based upon your financial statements. But the guy could never get out of liability, so he ultimately went to trial. He was given 500 names as potential witnesses, had to interview those 500 names at a very high cost in lawyer fees per hour. When they got to trial, 2 witnesses were called. Both of them exonerated the fellow, and the case was dismissed again I guess in that case on motion by the plaintiff or the defendant. The problem I'm posing to you here is that there's no way for anybody to look at those kinds of cases. Now, in the case of the FTC, I know there's a review process. In the case of the Justice Department, there's a review process. But basically, political appointees are not ever going to want to get involved in the details of a case. So to the degree that you've got an official in the Justice Department or any other agency that can bring a criminal prosecution, there's very little that can be done to oversee that process. And yet we get a tendency, for many reasons, to prosecute people in ways that those 2 examples demonstrate. It seems to me that we need somewhere to have oversight that becomes effective. In other words, a new administration takes over, new political people come in, they are loath to go in and say, show me the details of your case. In other words, I don't think the real world works like Law and Order works, where you've got a brilliant prosecuting attorney who tells the cops why their case doesn't work or why it does work and is deeply involved in every detail. That just doesn't happen, I think, in our system. What do we do to create a process? And I'm going to ask the whole panel, but I'm going to start with you, Mr. Nahmais, because of your particular experience, but also, well, we have very different views on this, but if we can start here and go through the panel and come back to Mr. Dickinson, I'd appreciate that, because I'd like to know what we can do. Do we have a committee like a Select Intelligence Committee where we have out guidelines in Congress and we have the ability to go in and look at particular cases? Do you set that up as a separate panel, an outside agency of some sort? Or do we just do it in this committee with more oversight staff?
The time of the gentleman is about to expire. I will allow each of the witnesses to give a very brief answer, 30 seconds or less, please.
Actually, I do believe it's in the interest of the chair to have a long answer, because this goes to the very core of the jurisdiction of this committee, which I think we would like to expand.
I understand we were very generous in the last round of questioning with the amount of time that went over. I'm just asking the witnesses to please pare down your answers to the essential points that you would like to make.
I'll try to be brief. I'm not familiar with the cases you discussed, obviously, but I think the system is set up in lots of ways to provide accountability for the types of decisions that are made in cases, both through, I think, our very high-quality career assistant U.S. attorneys, our U.S. attorneys who are confirmed by the Senate, and by the adversarial system and the other parties' abilities to fight through the system with review by the court and ultimately by juries. There is obviously a proper role of oversight by this committee or the Congress generally.
Mr. Nahmais,
the only concern I have is that it not happen while cases are pending, because of the risk of injecting political influences into what should always and invariably be nonpartisan and non-political prosecutorial decision-making.
Mr. Dickinson.
Justice should be the first stop, and this committee should be the second stop. I'm quite familiar with the IOC case if you want to talk about it.
Thank you, Mr. Dickinson. I appreciate your brevity. Mr. Terwilliger, sorry, tongue twister.
Thank you, Madam Chair. Mr. Cannon, you have raised so many important and in-depth issues that couldn't possibly be responded to in 30 seconds or 120 seconds. But I'd be happy to submit some thoughts on the questions you raised for the record subsequently. I will say this. When I served as a presidentially appointed United States attorney in the field, I thought the idea of oversight of my decision-making and exercise of prosecutorial discretion by the Department of Justice was extremely ill-advised. When I served as Deputy Attorney General supervising the nation's 93 United States attorneys and saw some examples of some of the kinds of things you're talking about, I formed a very different view. But I do think the responsibility in the first instance has to be at the Justice Department on the decisions on cases, and that Congress ought to have oversight on that to ensure that there are not improper factors and so forth, but also should exercise that oversight after the fact, as Mr. Nahmais suggests, and with a very light hand.
Mr. Garrett.
Just briefly, I would say that as to...
Could you please turn your microphone on?
As to prosecutorial discretion regarding charging, which I think was mostly what you were talking about, prosecutors have wide discretion for separation of powers reasons. Courts review that discretion very deferentially for good reasons. And the DOJ has promulgated the Thompson memo and the McNulty memo to provide guidance to organizations on how they go about making those charging decisions. So, I think it makes more sense to focus instead on what happens after a charging decision is made, and then there's the question of what does that agreement look like, how is it entered, how is it implemented, what remedies are included in it.
Thank you, Professor Garrett. I think that was the main crux of today's hearing. I would like to get through the final member who would like to question, because we've been summoned for votes across the street, and after this Mr. Johnson is allowed to ask questions. I think we will be able to dismiss our first panel. Mr. Johnson is recognized for 5 minutes.
Yes, thank you, Madam Chair. Professor Garrett, in the case of a non-prosecution agreement, there is no charging document that's filed. How can there be oversight on those cases where there's nothing filed with the court, there's no public record, it's a secret process?
I think those agreements are troubling, and one possibility would be if the department issued a guideline recommending against the use of such agreements. I don't see, unless there's some legislation, which I'm not sure how that would operate, that forbade the use of such agreements. Perhaps the guidance would have to come first from the department.
Mr. Nahmais, I see you.
Could I make a comment on that? I would disagree with Professor on that statement. As with Mr. Terwilliger, I've been working in this area for 25 years. I've represented companies doing this type of work all over the world. I think a non-pros agreement is a highly appropriate remedy in certain circumstances. There may be cases where companies are willing to make voluntary undertakings and provide certifications.
But it's done in secret, though.
I'm not sure I would use the term secret.
No public record?
There may be a public record, yes.
No requirement that there be a public record. Or
I'm not sure about the requirement,
process.
but I have personally engaged in non-pros agreements where there have been public documents so citing. I think Mr. Nahmais can explain further.
I think non-prosecution agreements are really at the core of the prosecutorial discretion not to bring charges. Those decisions by prosecutors not to bring charges against either individuals or companies have traditionally not been made public.
They involve the use of monitors, correct?
Some of them involve the use of monitors. Many of them don't. Many of the ones involving individuals involve conditions but do not involve monitors, obviously. One of the things is in the area of publicly traded.
But it's a secret process.
Well, in the area of publicly traded companies and others who have regulatory disclosure obligations, very often these agreements are made public by the affected entity. The department. This is another area the department has considered, but it is important that that we be careful to guard the rights of people who are not charged in prosecutions. And the fact that they are corporations versus individuals may or may not make a difference in an appropriate case.
Thank you. Mr. Dickinson, the Ashcroft Group will reportedly receive fees of approximately $52 million for 18 months of monitoring in the Zimmer case. Furthermore, the Ashcroft Group gets a monthly fee of $750,000 against a hourly billing rate, which tops out at $895 an hour. In your experience, is this reasonable compensation for monitoring Zimmer?
I'm sorry to say it's impossible to answer that in terms of the reasonableness factor. Every monitorship is different. Every monitorship has a different scope of work. Certainly that hourly rate would not be unusual for a very senior person such as the Attorney General, and depending upon the scope and the required activities, that may or may not be a reasonable amount.
Mr. Nahmais, U.S. Attorney Christopher Christie spearheaded the prosecution and the decision to enter a deferred prosecution agreements or an agreement with the 5 medical device companies who were engaged in the largest Medicare fraud case in recent history. This was a national case which affected thousands of Americans and involved hundreds of millions of dollars. How was Mr. Christie, as the U.S. Attorney for New Jersey, able to obtain the right to prosecute this case instead of other U.S. attorneys? And was the decision as to which office or which U.S. attorney would prosecute the case, was that decision reached from Washington at the Department of Justice, or was Mr. Christie just faster in asserting a claim to the prosecution in this national case?
I don't know the direct answer to that. I believe that some of these companies had extensive activities in New Jersey. New Jersey's U.S. Attorney's Office has been a leader in a lot of the major healthcare fraud cases in the country.
All right. Okay.
Under
thank you.
department policy, it's
right.
often the U.S. Attorney who acts first and best that takes the case.
All right. Thank you. Professor Garrett, do you have any idea of how many non-prosecution agreements and deferred prosecution agreements have been entered into by the Justice Department since 2003?
Yes, it's over 80.
Please use your microphone. And the time of the gentleman has expired. I will allow the witness to answer.
It's over 80 agreements, at least those that we've been able to locate.
I'm sorry, say that again?
We've been able to locate more than 80 agreements. There may be others that haven't been made public. I don't know about those, of course.
The time of the gentleman has expired. Mr. Cannon wished to be recognized for 30 seconds.
Thank you, Madam Chair. I want to again thank the panel for being here today. And as the chair knows, I'm deeply concerned about some of the abuses of prosecutorial discretion and arbitrary prosecution, in particular, prosecution by the Department of Homeland Security of groups that haven't committed crimes but may be harboring or may have on their payroll without being able to tell who they are, people who are illegal aliens. That would include the SWIFT prosecution or the raid of the SWIFT company and the raids of various dairies and other groups around the country where there seems to be no consistent thought behind how it's done except to terrorize industries. And that, I think, is one of the issues that this committee should clearly have jurisdiction for. And I want to thank the panel for their opinions informing us on what the nature of that jurisdiction should be as it relates both to the deferred prosecution and also to prosecutorial discretion. And thank you, Madam Chair.
I thank the gentleman. And issues of prosecutorial discretion are something that I think is sort of tangential to what the crux of today's hearing is. And I've enjoyed the discussion. I want to thank the first panel for their testimony. I'm going to excuse you now so that members can go across the street to vote, and we will remain in recess.
Good seeing you.